Good morning, Your Honor. This is Stephen Berman and Lydia Anderson-Dana from Stolborn on behalf of plaintiffs. Is my audio coming through okay for the court?
It is.
Okay, thank you.
Your Honor, this is Emily Matasar, and I'm with Chris Crane on behalf of the defendants.
Thank you.
Your Honor, this is Daniel Cairns. I'm here on behalf of the interveners.
So, Your Honor, this is Chris Crane for defendant Lincoln County, and I actually litigated that for the county at LUBA. And I'll get back to this, but the bottom line is I think that the decision that was appealed in that case, County Ordinance 523, was not a land use regulation under the applicable case law. Whereas the county's position in this case on the initiative measure is that it is, and that's for the following reason. The best way to understand this, I think, is by reference to the Lincoln City case on short-term regulations. There, the city actually regulated short-term rentals in its zoning ordinance. It also had licensing standards. So you had to get land use approval for your short-term rental. You also had to get a business license. And when the city adopted those regulations, it included in the zoning ordinance a provision that requires you to get the license to run your short-term rental. And the people who had challenged that decision argued that because of that reference in the zoning code, the city's licensing regulations were also land use regulations, and they challenged an amendment to the licensing regulations. And LUBA concluded that a mere reference in the zoning ordinance to other regulations does not make those regulations land use regulations. So in this case, the LUBA case that was just transferred to you, the county in Ordinance 523 amended the licensing regulations, but there was no connection to the county's land use code, Type 1 of the county code, Lincoln County Code. So there was not that, what LUBA calls a direct connection. There were no implementing standards for the comprehensive plan in Ordinance 523. And we pointed that out to LUBA, and LUBA said, you're right, it's not a land use decision. And they transferred it to the circuit court. In this case, the measure itself refers to the comprehensive plan and expressly states it's intended to implement the comprehensive plan. And so the county's position is that's more than a mere reference. That makes these licensing regulations makes them standards that implement the comprehensive plan, and that makes it a land use regulation subject to LUBA's jurisdiction. So that's the distinction, Your Honor, that we argued at LUBA, and LUBA agreed. Because the Ordinance 523 did not only amended the licensing standards, that did not do anything to implement the comprehensive plan. It wasn't a land use regulation, whereas we believe the measure, because it expressly says it's intended to implement the comprehensive plan, is a land use regulation and should be over at LUBA. So that, in a nutshell, Your Honor, that's what we argued at LUBA, and that's what I think the distinction is between these two cases. No, that's not correct, Your Honor. We believe LUBA does have jurisdiction over this initiative measure. Interveners do not believe that it's a land use regulation subject to LUBA's jurisdiction, but the county has always been of the opinion that the initiative measure is a land use regulation and should be reviewed by LUBA.
I would, Your Honor, this is Dan Cairns for the interveners, if I might. We filed an opposition to this joint motion to dismiss and transfer this case over to LUBA. I disagree with Mr. Crean's characterization of this ordinance, and I think that LUBA's actions so far are consistent with our arguments. And I think one of the best precedents that you can look at for deciding this question, this basic jurisdictional question, is this measure a land use decision or not, is some of the litigation over Lincoln City's short-term rental regulations. And I cited them in some of the materials that I submitted to you in this motion for summary judgment and our response, and I think the plaintiffs did also. The case that's most critical is Oregonians in Action versus Lincoln City. It's came down April 22nd, 2015, and it challenges three different ordinances that Lincoln City adopted And I notice in, for example, the plaintiff's response and reply in this case, they focused on the wrong section of LUBA's opinion. LUBA reviewed the challenge to Lincoln City's short-term rental regulations, and that's what Lincoln City called Ordinance Number 2014-23. And they dismissed the appeal of that. And the way Lincoln City has structured its short-term rental regulations, there's a lot of and city zoning refers to residential zoning, and so the case that's before you now, this measure, is pretty similar to how Lincoln City set up its short-term rental regulations. For some reason, plaintiffs focus on the city's amendments to a zoning ordinance. That's clearly a land use regulation. LUBA held jurisdiction on that. There's lots of references in Lincoln City's land use regulations to short-term rentals, whether they're a use allowed in the zone or not, and those sorts of things. And quite frankly, that aspect of LUBA's opinion in Oregonians in Action that the plaintiffs are citing has nothing to do with this case. This is a short-term rental regulation. LUBA finding that it didn't have jurisdiction over Lincoln County's Ordinance 523. That ordinance was pretty not land usey. There were like no cross references to the county's land use regulations. It was pretty sterile, being just a amendment to the short-term rental regulations. The measure that's before you, in this case, Mr. Crean said that it expressly implements the comprehensive plan. It doesn't. It doesn't even say that. The only reference to the comprehensive plan is in the purpose statement, where it says, because of their location in said residential zones and their specific characteristics and potential impacts, short-term rentals in dwellings in unincorporated Lincoln County require special consideration so they properly operate with respect to the comprehensive plan and the objectives of the underlying zoning districts. That's the only reference to the comprehensive plan. It doesn't say it implements the comprehensive plan. Land use regulations, they talk about different parts of a jurisdiction being suitable for different uses. The short-term rental regulations that are before you are an attempt by the voters to curb these business uses so that they are more consistent with commercial type settings and keeping them out of places that are more consistent with residential type settings. That doesn't make them something that implements the zoning ordinance, that implements the comprehensive plan, because they simply don't do that. And like Lincoln City's regulations, this measure references underlying zoning. Lincoln City's does that. LUBA said that wasn't enough to make Lincoln City's STR regulations land use regulations. It's okay to refer to the fact that there's zoning out there, that they're residentially zoned areas. That doesn't make these business regulations zoning regulations. So I think that this case is not really analogous to the county's Ordinance 532 that had no references to zoning. This one does have references to the underlying zoning, just like Lincoln City's did. That wasn't a land use regulation, neither is this one. I don't think that this should be dismissed because LUBA doesn't have jurisdiction over it. So those are my comments, Your Honor.
Your Honor, may I speak briefly on behalf of the plaintiffs? I believe the court's question was, initially, does the transfer of one of the LUBA challenges to the court impact plaintiffs and defendants' request that the court transfer this matter to LUBA? And from plaintiff's position, it does not. We are not counsel of record on the two proceedings that were filed in LUBA. We brought this challenge because it involves the use of the initiative power and whether that was a proper exercise, and if so, what is appropriately undertaken through the initiative. We had articulated before, I know Ms. Anderson-Dana articulated a couple of weeks ago with the court, we believe that issues of concurrent jurisdiction on this matter with the court and with LUBA. There are some issues that are clearly only for the court, compliance with Chapter 203, for example, compliance with some other procedural matters. Those are kind of proper initiative things. LUBA can decide those as well. And we were operating under the understanding, after we conferred with county council, that it made sense to have everything involving the initiative in one jurisdiction so that we didn't get a situation where we had potentially conflicting opinions and then conflicting appeals going up and nobody knowing how one should act in the interim. So that was our basic thought process on this. And to answer the court's initial question, we continue to believe that it would be fine if this case got transferred to LUBA. We haven't changed our opinion on that. I don't want to get too far ahead on some of the merits for today's argument because we're not counsel of record on those two matters that were filed in LUBA. And so I get a little uncomfortable with the defendants and the interveners arguing about things that aren't pertinent to our case here. We just can't respond to them, and so I don't want to kind of get lost in that, if that makes any sense.
Sure, it does. And I just
Thank you, Your Honor. We're going to split our time, and I'm going to focus predominantly on the issues surrounding kind of the big picture stuff about the initiative process, and then the history of this measure, and then some Chapter 203 issues. Ms. Anderson-Dana is going to focus predominantly on the land use related issues. And then if we have additional time, I'll come back and talk about severability and just for a moment about the attorney's fees issues that have been raised, but I don't think are ripe yet to be determined in this matter. We hope not to use all the court's time, and obviously we are here predominantly to answer questions. We've briefed this extensively. I know the court has a briefing and we'll have an opportunity to review it. We filed, and I think the county as well filed reply briefs yesterday. I don't know if the court has received them or if the court would like us to forward bench copies. We can do that after the hearing. I think we were both scrambling to get that filed and get ready for today's hearing, and so we didn't email a bench copy, but we can do that at any time.
I have them all. I received all of them and have them printed here.
Okay. So we're here on a facial challenge to Lincoln County Measure 21-203, which was passed at the November 2nd, 2021 election. It's plaintiff's view that the measure is an improperly enacted ordinance that is a land use regulation inconsistent with Oregon law. Plaintiffs are clients or Lincoln County property owners with short-term rental licenses. They're also residents, taxpayers, and electors who would be detrimentally impacted if the measure is allowed to go into effect. And they're representative of the over 530 short-term rental license holders in unincorporated Lincoln County. And circling back to what we were saying before, we're not challenging other ordinances that the county may have enacted relating to short-term rental licenses. The county has taken some action after the court issued the preliminary injunction in this case, and we're not challenging those county ordinances. I understand those are the matters that are being addressed in the LUBA proceeding. We're really here to challenge the measure or the initiative, and whether or not the county can accomplish the underlying goals it sought to accomplish in the initiative through some other action is not the issue that we are here to debate. What we are here to debate is whether this initiative, this measure, was a proper exercise of county authority. And our position is that it was not. The measure itself amends sections 4.405 to 4.460 of the Lincoln County Code to prohibit and limit short-term rental licenses in unincorporated Lincoln County in residential zones R1A, R1, and R2. As Mr. Crane was saying at the outset, the measure restricts short-term property uses to, quote, operate with respect to Lincoln County's comprehensive plan and zoning code. It effectively prohibits STRs in zones R1A, R1, and R2 in unincorporated Lincoln County. It labels existing short-term rental uses as non-conforming uses and makes that use non-transferable. It wholly eliminates short-term rentals in R1A, R1, and R2 zones over the course of 5 years with a very restrictive hardship exemption that ultimately will lead to the elimination of those short-term rental uses as well, although it's unclear how those will get stretched out. It also prohibits, and I'll talk a little about this a little bit more in a minute. It prohibits having more than one short-term rental license in unincorporated Lincoln County, or having a short-term rental license in both incorporated city in Lincoln County and in unincorporated Lincoln County. And finally, it immediately reduces occupancy limits and imposes other constrictive wastewater management requirements on existing short-term rental licenses. As we highlighted in our summary judgment briefing, this measure was not free from controversy before it was put on the ballot. Before it qualified in a November 16, 2020 memo to the County Commission, then Lincoln County Council, Attorney Wayne Belmont, wrote that he had concerns about the legality of the initiative. And after it qualified, but before the voters voted on it, Mr. Belmont was more emphatic. He stated at a September 29, 2021 County Commission meeting, quote, "The ballot measure takes the approach of dealing with these STR uses as land use regulations. And I already have articulated very clearly that I think there are a number of legal issues and questions in dealing with this particular issue through the land use system." In its answer, the county has acknowledged that these statements were made. And at that same commission meeting, all three commissioners voiced opposition to the measure and expressed concerns that it was legally flawed. That is the background upon which the voters voted on this measure. They were on notice about the legal concerns, and the legal concerns were flagged. And what we end up with is a very awkward position for the county, where its own in-house lawyers said you can't do it this way, but the voters passed it, and now the county is properly obligated to defend it. That is the county council's job. The voters approved this. They now have to defend the measure. But the backdrop was the measure's opponents were saying it was improper, and the county was saying it was improper. And then the voters passed it anyway. Three big picture concepts that are going to kind of permeate my argument and Ms. Anderson-Dana's argument. The first is the measure's approval by the voters is entirely immaterial to whether or not the measure is legal. The county and interveners repeatedly stress that this measure was approved by voters. That doesn't matter. That is not a legitimate test of whether something is constitutional or valid. The voters don't get to decide whether or not something complies with the Constitution. The voters don't get to determine, of the county, don't get to determine whether or not something complies with overarching state law. That is not up to the voters. Voters' approval of the measure is why we're here. If they hadn't approved it, we couldn't bring this challenge. But it is immaterial to the legal issues before the court. The text of the measure itself controls the legal analysis. This is our second kind of big picture theme. And we want to keep coming back to that because there are 2 or 3 places that we'll talk about where the county and interveners urge the court to move away from the clear language of the measure. State v. Sagdahl, 356 OR 639, is a case that we cited in our brief about the text of the measure being controlling. It doesn't matter. There are 20 other cases from the court that go for the same point. One looks to the text. The county and interveners cite a case called, I believe, State versus Allison, 143 ORAP 241. That's a case from 1996 that preceded State versus Sagdahl. Allison stands for the proposition that the court may also look to context of the measure, legislative history. You can look to statements in the voters' pamphlet, other statements that were presented to voters when they contemporaneously voted on the measure. And that's correct. I mean, that can influence the court's decision in its reading of the measure. But in State versus Sagdahl, the court was very clear. It said, we caution about relying on statements of advocates such as those found in the voters' pamphlet because of the partisan character of such material. So again, as the court goes through the analysis, we would request that it start with a text consistent with the overriding Supreme Court case law on this. And as it looks to other things like voters' pamphlet statements, the ballot statement, ballot title, what else was on the ballot, that is material to what voters were thinking, but it ultimately can't dominate over the actual text of the measure. The language always controls. The third thing I'd kind of big picture thing is the anomaly between what this initiative was, what this measure was, and what an ordinance normally looks like. And in our reply brief, we provide the court with a copy of Lincoln County Ordinance number 487. I believe that was an ordinance that related to the initial kind of short-term licensing program adopted by the county. And we put that there not because of the substance of that ordinance, but because of the structure of the ordinance. This is about how an ordinance gets written. An ordinance has generally an overarching statement of purpose. It then has an ordaining clause being enacted by the people of Lincoln County, blah, 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 blah. There's specific language, and we'll discuss that in a minute. It then has a series of sections. Section 1, Section 2, Section 3, Section 4, each which imposes or creates a new provision of law. And then towards the end, it will have a separate severability clause, if the drafters want to include a severability clause, and an effective date. Now that stands in stark contrast to how the measure actually appears. The measure, which is, I believe we've all attached it as an exhibit to our summary judgment motions, the measure has none of those features. The measure simply provides proposed amendments to sections 4.405 to 4.460 of the code. It doesn't have separate sections. It doesn't articulate which sections of the code are being changed. It does highlight in bold and brackets, I believe, or bold and italics, what's being added and what's been deleted, but it simply doesn't follow the ordinary structure of how a measure is typically written. Two specific arguments I want to discuss that we've briefed extensively, so I will not get into the weeds, but I'm happy to answer any questions the court may have. I want to address some of the ordinance itself failing as an ordinance issues, separate from the land use issues. And these both come up under Chapter 203 of the Oregon statutes. The first I want to discuss is the Ordaining Clause. And the parties have briefed this extensively. The court has some materials. So I'm just going to give some bullet points. ORS 203.0354 provides the voters of the county with the authority to, quote, propose county ordinances through the exercise of the initiative power. ORS 203.045 then sets forth certain requirements for ordinances adopted by the commission or by initiative. And for ordinances adopted by initiative, such as this measure, ORS 203.0451B is as explicit as it can be. The ordaining clause of an ordinance adopted under ORS 205.035 shall read, in the case of adoption or ratification by the electors of the county, quote, the people of name of county ordain as follows. The requirement is mandatory. It is not optional. This is what the legislature decided back in the 70s, what an initiative referred to the people had to contain. It's very clear. And finally, to make sure that this was followed, ORS 203.060 requires that ordinances adopted by the county's voters by initiative, and again I quote, shall be subject to judicial review and invalidation on account of procedural error in adoption. This is what the legislature determined. This is what the legislature requires. It's the most basic, fundamental starting point for an initiative to be valid. You can't get to step B without completing step A. The parties agree that this measure does not contain an ordaining clause. It does not contain the language required by statute. That should be the end of the story. We are not aware of any cases interpreting or applying the current version of ORS 203.045. We don't believe any are necessary in the light of the clear statutory directive. The Oregon Supreme Court cases from going back to 1880 are clear about this. State v. Wright, the Supreme Court said, if the bill was without an enacting clause, it could not be law. Now, in State v. Wright, the law had an ordaining clause. Someone, after the measure had been passed, had written through it with a black pen, but it actually had an ordaining clause. In Colby versus City of Medford, 85 OR 485, the court goes on to say, basically, if the Constitution, state law, or a county charter requires an ordaining clause, then there has to be one. At the time Colby was decided, there was no state law requiring an ordaining clause. ORS 203.045-2B had not yet been passed. But the court was clear that if one were in place, it had to be complied with. There's also similar language in City of Astoria versus Malone, 87 OR 8892, 1918. County and chief petitioners raised two arguments. The first is, this is a technical requirement, and the court doesn't have to adhere to it, and the measures drafters didn't have to adhere to it. How they categorize this requirement is immaterial. It is a mandatory statutory requirement set by the legislature for initiative petitions. The measure's proponents do not get to choose which mandatory requirements they comply with and they don't comply with. This is a requirement they have to follow. Chief petitioners can disregard this no more than they can disregard the requirement that an initiative have one subject, must contain the full text of initiative, of the law being amended, and must be legislative and not administrative. They don't get to pick and choose. They didn't do that here, and it is a fatal flaw. The second argument that the county and the initiative's proponents articulate is, well, voters passed this. It's popular. Court shouldn't overturn it now. And in support of that, they cite a series of cases that I respectfully submit are entirely immaterial to this discussion. They cite Miles v. Vitach, 189 OR 506. And that's a case that involved a party's failure to file a campaign expenditure report. Kiernan versus City of Portland, 57 OR 454. That involved a minor error in the ballot title for the initiative, not the actual substance of the measure. Lindstrom versus Myers, 273 OR 46. Similarly involved whether the initiative's proponents had properly authenticated a campaign expenditure and contribution report. Hewitt versus Yurkovich, cited by interveners in their briefing, 27 OR App 127, also involved the late filing of a campaign and expenditure report. None of these cases address an underlying flaw with the structure of the legislation that had been proposed. These go to procedural issues, not to the actual substance of the language of the actual law that they are trying to pass. The closest defendants come is Beeman versus Kelsey, and that's 66 OR 70. It's a 1913 decision. That case involved an ordinance passed by the city of the Gold Beach Charter mandated ordaining clauses, and that ordaining clauses contain specific language. And in that case, the ordinance had an ordaining clause, it's just the language wasn't entirely consistent with what the charter required. I don't think that case gets defendants anywhere near where they need to be. In Beeman, the issue was the city's compliance with its own charter requirement. It predates the statutory requirement in ORS Chapter 203 that mandates ordaining clauses for county ordinances. It just predates it. You're mixing apples and oranges. Here you have a clear statutory directive. Going to move on from the ordaining clause to briefly talk about ORS Chapter 203.040 because this is a particularly interesting provision and it's a place where the county and interveners read the statute, read the measure that was passed differently. ORS 203.040 prohibits counties from infringing on the authority of incorporated cities. It provides in relevant part ordinances adopted under ORS 203.030 to ORS 203.075, an exercise of the police power, shall not apply inside an incorporated city. Here, as we discussed earlier, this measure was adopted pursuant to the initiative authority in ORS 203.035 sub 4, so the statute is clearly triggered. And again, pursuant to ORS 203.060, the court shall review such ordinances for statutory compliance. Measure section 4.425A provides effective upon adoption of these measures. I'm going to paraphrase here. A holder of a short-term rental license in a R1A, R1 or R2 neighborhood shall not be eligible to apply for or hold a short-term rental license for any other property within Lincoln County. Within Lincoln County. This provision of the measure does not say just unincorporated Lincoln County. It says within Lincoln County. There are other sections of the measure, multiple other sections, that use the phrase unincorporated Lincoln County. Section 4.4052, Section 4.410, Section 4.405. But Section 4.425 sub A refers only to Lincoln County, not unincorporated Lincoln County. There is a rule of statutory construction that the Supreme Court applies that is kind of the black letter law that goes back to law school days, which is use of a term in one section and not another section of the same statute indicates a purposeful omission. In other words, if the measure's drafters refer to Lincoln County in one provision of the measure, but refer to unincorporated Lincoln County in all the other provisions of the measure, that should be viewed as deliberate and intentional. Now, this is where the county and the measure's drafters, interveners, disagree. The county says we should read the word unincorporated into that section. That's clearly what the drafters' intent were. If you look to the ballot title, if you look to statements that were made before the commission, while there was some confusion about whether this applied to all of Lincoln County or unincorporated Lincoln County, people seemed to think that this was really just about unincorporated Lincoln County. And that's all we're trying to regulate. The challenge with the county's position, frankly, is it ignores the plain text of what's there. The decision by the drafters to only refer to Lincoln County in this one provision of the measure rather than to unincorporated Lincoln County. The interveners are more forthcoming about what their intent was here. And if you look, for example, at their summary judgment motion at page 20, They write as to section 4.425A, it is intended that, quote, a person who already operates a STR in a city within the county would not be eligible for a county STR license under this provision. They double down on that on page 26 of their summary judgment motion, where they argue that when they drafted the measure, their intent was, this section requires the county, when evaluating STR license applications, to consider whether the applicant holds STR licenses in other parts of the county, parentheses, even within incorporated cities. Here's the problem with that. Section 4.425 sub A makes issuance of an STR license in unincorporated Lincoln County contingent on whether an incorporated city has issued a license to the same person. This is a direct interference with the incorporated city's authority. It serves as a backdoor limit to the incorporated city's police power. In essence, what interveners are arguing and what the text of the measure says is the sheriff could fine an STR license holder in unincorporated Lincoln County if that person also holds an STR license in Lincoln City or an incorporated Walport. It also says the county would deny or revoke an STR license holder's license in unincorporated Lincoln County for holding a license in Lincoln City or an incorporated Walport. The county doesn't get to decide what rights it gives to residents and property owners based on what's going on outside of their jurisdiction. That's the point of ORS 203.040, to prevent county action from infringing on city authority. Your Honor, those are the topics that I want to cover. Ms. Anderson-Dana is going to address the land use issues and the constitutionality issues. I don't know if you have any questions on those topics, but otherwise I will kind of pass my time and mute myself and hand it over to Ms. Anderson-Dana.
Ms. Anderson-Dana.
Good morning, Your Honor. Can you hear me okay? Okay, better than last time. All right. I'll be discussing, as Mr. Berman said, why the measure is invalid under Oregon statutory land use law and also is unconstitutional. The measure violates and is preempted by Oregon statutory land use law for 4 reasons, which I know we've briefed extensively, so I will touch on these issues briefly and, of course, answer any questions you may have. The first issue, which was already discussed a little bit at the beginning of this hearing, is that the measure is a zoning and land use regulation under ORS chapters 197 and 215. And there's 2 key reasons why this is true. One of them the county already touched on. And that's that the measure is an ordinance that establishes standards for implementing a comprehensive plan. One of the definitions of land use regulation under ORS 197-015 subsection 11 is a similar general ordinance establishing standards for implementing a comprehensive plan. As we've discussed, section 4.405 specifically does this. It states that short-term rentals in dwellings in unincorporated Lincoln County require special consideration so they properly operate with respect to the comprehensive plan and the objectives of the underlying zone districts. In other words, the measure specifically intends to make short-term rentals in unincorporated Lincoln County meet the standards that are inherent in the comprehensive plan for Lincoln County's code. The measure is also a zoning ordinance because it regulates how property can be used in zones R1, R1A, and R2. Another definition of land use regulation under ORS 197-015 subsection 11 is any local government zoning ordinance. Black's Law Dictionary defines a zoning ordinance as a city ordinance that regulates the use to which land within various parts of the city may be put. And here we have a variety of sections in the measure that go to this question of what the land within unincorporated Lincoln County, what kind of uses it can be put to and where. And section 4.405 states that a finding and purpose of the measure is to regulate properties in areas zoned R1A, R1, and R2. Section 4.421 limits licenses based on zoning designation. Section 4.422 makes short-term rental uses non-conforming based on zoning designation. And Section 4.423 prohibits short-term rental uses after 5 years based on zoning designation. And I submit that this is different from the some of the licensing ordinances discussed that Lincoln City has, which we found in Oregonians in action, and even some of the other ordinances that may have been passed around the state. The difference here is that there's not merely just a glancing reference to zoning designation. What you have here instead is a ordinance that completely eliminates the use of short-term rental uses. And I would like to point out that the measure uses the term short-term rental uses. It does not completely eliminate licenses. It says short-term rental uses are non-conforming and that those uses will fade out and be completely limited after 5 years. And the hardship provision that is in, I think, 4.423 or 4, I'm sorry, can't quite remember, also talks about short-term rental uses. We're not talking about licenses. And even if we were, the effect is the same. The effect is that individuals who have short-term rental licenses can no longer use their homes for short-term rentals after 5 years. And if you look to the zoning subsections of the code, the county code in sections 1.1701 and elsewhere, or if you look to the Lincoln City Code, which we discussed in our reply, this looks exactly like those zoning regulations. And it doesn't matter that this measure was put into the business licensing scheme, because it matters what it does. And Morgan v. Jackson County tells us that business or occupational licensing is a system that does not regulate with regard to particular locations in the use of real properties. And that's what this is a question about. You can call it a license, but if it bans the use, then it's a zoning ordinance. And you need to follow, the question there is that then you need to follow county and state procedural and substantive requirements for land use regulations. And that's what I'll talk about next. The measure violates ORS 215130 subsection 5 by impermissibly making short-term rentals non-conforming uses. So ORS 215130 subsection 5 governs the authorities of counties to regulate non-conforming uses. And that's a quote from City of Mosier v. Hood River Sand and Gravel and Ready Mix, 206 OR App 292. The two key provisions for our purposes are first, the statute says the lawful use of any building, structure, or land at the time of enactment or amendment of any zoning ordinance or regulation may be continued. And second, says a change of ownership or occupancy shall be permitted. The measure violates this provision in two ways. First, it expressly designates short-term rental use as non-conforming or unlawful in section 4.422, but then in section 4.423, it phases it out over 5 years. But ORS 215130 subsection 5 denies counties the power to remove, ban, or phase out a non-conforming use under a local ordinance that makes a previously lawful activity unlawful. Second, the measure expressly prohibits transfers to new owners, even though ORS 215130 subsection 5 requires counties to allow a non-conforming use to be transferred to new owners. And the key points that I'd like to point out to Your Honor is that first, the interveners, defendants, and arguments in the briefing disregard the plain text of the measure. The plain text of the measure in these sections in particular talks about short-term rental uses. It doesn't talk about licenses as a noun. It talks about uses. And again, Morgan tells us that business or occupational licensing doesn't look at where uses are located. It talks about how you might do something or what sort of skills or permits you need to apply. It doesn't say where you can do things. And finally, no one has been able to point to an understanding of the term non-conforming use outside of land use law. And plaintiffs, we weren't able to find any in the case law in Oregon. Non-conforming use is a land use term. And if the measure's proponents wanted to do what they did, they needed to do it a different way. And there's a reason why we have these statutory protections. And then my next point goes very quickly to the public hearing and notice requirements in ORS 215503 and ORS 215223. 215503 requires individual notice. 215223 requires public notice and hearings. And no one disputes that there was no notice given or public hearings held on the measure. But the issue is whether the requirement in these references in these statutes to ordinance enacted by governing bodies means that they don't apply here. And there's two responses to that. First, LUBA has addressed a similar issue in the case Riverbend Landfill Co. v. Yamhill County, which is 24 OR LUBA 607, and says, well, for the purposes of timeliness of a petition, the action of the county, the governing body, is by certifying the election results. And that's one way to look at it. The county acted here, they certified the election results. That's why that they're a party in this case and not just the interveners. They have a role to play. And so they can't just avoid these statutory protections by saying, oh, we didn't pass this. That was the initiative's proponents. And second, if that's not true, then the answer is not that the county gets to avoid statutory protections in ORS 215. That's not the role of the county. That means that the initiative is not valid at all. And that's what Dan Gile, which is 113 ORAP 1 tells us. That was a referendum, which actually involves more involvement by local government than an initiative. And it says if a local government can't follow ORS Chapter 215's procedures by passing a land use regulation via popular vote, then the ordinance isn't valid at all. The answer is not that then those procedures just go away. And finally, on the land use issues, the measure 49 applies and preempts the measure. And as we discussed in our briefing, the measure is preempted by numerous state laws because it cannot operate concurrently with them, including the laws that we just talked about. But I'm going to look at Measure 49. And the two questions that matter here is, one, does Measure 49 apply here? And two, if so, does it preempt the code? The answer to both is yes. Measure 49, which is ORS 195.300 and further on, applies here. Under 195.305 subsection 1, public entities have to provide just compensation if they enact land use regulations that restrict the pre-existing residential use of private real property. Here, the only real debate is whether the pre-existing short-term rental use was residential. And as we pointed out in our briefing, the Oregon Supreme Court said in Yogman v. Parrott, 325 OR 358, short-term rental use is residential because short-term renters use short-term rentals as dwelling places, which is a commonly understood definition of residential. I talked about there might be another definition of residential, which is to live somewhere for a long time. I pointed out that someone who doesn't live in their home all of the time, or maybe only uses it as a vacation spot and doesn't rent it out, that would not be considered residential either. And we've cited numerous other cases in which courts and other jurisdictions found that short-term rental use is residential. And for that reason, Measure 49 does apply. And we submit that Measure 49 also conflicts with the measure for two reasons. The hardship exemption under Section 4.424 gives only 60 days to a homeowner to apply for an exemption, which is much shorter than a statute of limitations of 5 years in Measure 49. And a longer amortization period cannot replace just compensation under Measure 49. The big picture issue that I would like to address with the land use issues is that this is a land use regulation the county is enacting, and that requires the county to comply with the procedural and substantive requirements of state statutes and their own code. You can tell it's a land use regulation by looking at the text of the measure, similar provisions in the code, other zoning codes such as Lincoln City's and state law. And more importantly, the county cannot disregard protections granted to its own constituents by state law and the code itself merely because an ordinance was passed by initiative and the initiative's proponents chose to put that ordinance in the business licensing section of the code, which was a choice that the county's own attorneys thought was improper. And I'd like to now move on very quickly to two reasons why the measure is unconstitutional. And the first one is that the measure violates Article 1, Section 21 of the Oregon Constitution, which prohibits the passage of laws that impair the obligation of contracts. The plaintiffs here have put in numerous declarations into the record about how the measure will impair their currently existing rental agreements. First, will affect rental agreements that were made under prior occupancy rates. And interveners argue that those occupancy rates will not be readjusted until licenses are reapplied for every year, but the measure makes it totally unclear how that process is supposed to go forward. I do not think it's unreasonable for plaintiffs and other landowners to think that perhaps the measure now makes it effective as of the date of the measure, unlawful for them to continue renting out properties at the previously higher occupancy rates. And quite clearly, Section 4.425, as Mr. Berman discussed, invalidates the short-term rental licenses of plaintiffs and other landowners with multiple licenses, which is 3 of our 4 plaintiffs have multiple licenses. And the measure itself says that it is unlawful to hold a license as of the date of the effective date of the measure, meaning that our plaintiffs who now have multiple licenses can't rent more than one of their properties, and they don't know which property that they can't rent from, and they don't know how that process is supposed to take place. But they do know that it impairs their contracts, and it's going to make them cancel some of their rental agreements. And that issue goes to the last issue I'd like to discuss, which is the measure is unconstitutionally vague. We gave 3 examples in the briefing of why it is unconstitutionally vague, but I'll point just to Section 4.425, which I just discussed, which bans individuals from applying for or holding multiple short-term rental licenses. The measure provides no guidance as to which of these multiple licenses will be revoked, when and how such a process will take place, whether this provision applies in the incorporated cities of Lincoln County. I submit the fact that all 3 parties here disagree about what this provision of the measure means points to the fact that it's vague. And I'm not sure how landowners who are often not attorneys are supposed to read the measure and understand what they can and cannot do and what they might be penalized for doing. Section 4.422, which has restrictions on transferability, also conflicts with 4.425, which has different restrictions on transferability and contains certain exemptions. And finally, Section 4.422, which describes non-conforming use, directly conflicts both with the code's description of non-conforming use and definition, as well as state law. And with that, I'll turn it over to Mr. Berman.
Thank you, Honor. I want to just briefly touch upon 2 more points, unless the court has any questions from Ms. Anderson-Dana. I want to talk briefly about severability. What does the court do with an initiative that has some or multiple invalid provisions? There's kind of two overall approaches. The first is if a measure is improperly enacted or improperly adopted, it's not severable. And that's the Lane County Transit case 337 OR 161 that we cited in our briefing. And here we've discussed already reasons that the measure itself was improperly adopted, predominantly the non-compliance with provisions, the requirements of Chapter 203, which impose on this court an obligation to invalidate the measure if it does not comply with the statutory requirements. Additionally, ORS 174.040 addresses severability. And as the county points out, there is a presumption of severability. In other words, you start with a presumption that if there are invalid provisions and valid provisions, you can excise the invalid provisions and let the valid provisions survive. But the statute 174.040 says you can't do that, or one cannot do that under 2 circumstances. The first is if the remaining parts are inseparably connected and dependent upon the valid parts. And the second is if the remaining parts are incomplete on their own. In essence, if an invalid provisions can't be segregated out from the valid provisions, the entire measure is invalid. Additional complications arise in a circumstance like this where the measure was passed by initiative petition and a vote of the voters, because we don't know what provisions the voters liked and what provisions the voters did not like. Maybe they liked some provisions, maybe they didn't. Maybe they would have voted for the measure had it contained the invalid provisions, but not voted for it without the invalid provisions. That intent, we can never, ever, ever discern. We can't go back. So even if one could properly think that some of the invalid provisions can get cut out from the other, we don't know how to assess what the legislative intent was on this, what the voters' intent was when they voted for it. Defendants rely on Clear Channel versus Portland 243 or Act 133 for the proposition with which we agree, that if the invalid provisions can be severed out, the court should do that. The problem is, and as even Clear Channel says, we still face the same difficult problem, namely what provisions of the city code should be severed. Now in Clear Channel, it was easy because the provisions that ran afoul of the Clear Channel involved regulations on what could be contained in billboards in the city of Portland. And the regulations that were determined to be invalid were all passed in 1991. So one could look at these subsections that were passed in 1991 and take them out and let the rest of the ordinance survive. We don't have that benefit here because, as we discussed earlier, this entire measure was just kind of dumped without subsections or anything. It's just one massive amendment to Code Chapter 4. And the initiative itself, the measure, did not contain a severability clause. They try to rely on the severability clause already in existence in Chapter 4 by implication. But the problem is in discerning the intent of the voters. It's impossible to know which of these sections the voters would have chosen had they known that some of them were invalid and inseparable. We can't get into a collective voter's mind. I want to also briefly touch upon the attorney's fees issue. Plaintiffs allege the right to recover attorney fees under the principles articulated in Gears versus Myers and DeYoung versus Brown. When parties are protecting an important public right and conferring a substantial benefit on the public, they're entitled to recover fees. We're not there yet. We have to win before we can seek recovery of fees. And ORCP 68 C sub 4 kind of sets forth the procedure for a party seeking fees. So I don't think the fees issue is properly before the court. I do think that we have to allege it, and I think we've properly alleged it. I think defendants and interveners kind of confuse what plaintiffs need to do to show standing, that they have licenses that they would be harmed, with them pursuing some kind of own pecuniary personal gain, which they're not seeking. They're not seeking to recover damages. They're seeking to vindicate the rights of themselves and people similarly situated. The county has cross-moved for fees under ORS 20.195, which allows for attorney fees only when there's no objectively reasonable basis for bringing a claim. And respectfully, I do not believe that statutory source is appropriate for three reasons. The first being, we do have an objectively reasonable basis to bring a claim. No one moved to dismiss our case for failure to state a claim. And in fact, to the contrary, we obtained a TRO and a preliminary injunction, which is a pretty clear indication that we're proceeding in good faith and with valid, viable claims. And finally, the last point is, it's not just us saying this. It's William Belmont. It's county council saying that this measure has significant legal problems. And so the suggestion that there's no objectively reasonable basis for us to pursue this case, when county council, before the measure passed, and the commission said, county council said, it's got problems. And the commission said, it's got problems. And we're not bringing those problems to the court and seeking justice. there is a reasonable objective basis for pursuing these claims, and we respectfully request that the court grant summary judgment in our favor. Thank you.
Your Honor, Emily Madisar, representing the county defendant. I am going to speak a little briefly. I will try to be concise because, as both Mr. Berman and Ms. Anderson-Dana referenced, the issues have been thoroughly briefed. And of course, I am available to answer any questions. I will, I think Mr. Crane and I will sort of tag team just like Mr. Berman and Ms. Anderson-Dana did, but I will start. So as you well know, the measure was drafted as an initiative petition in response to the community's concerns about short-term rentals in unincorporated Lincoln County and their effect on the livability, and especially in R1, R1A, and R2 zones. And the measure appeared on the ballot last November and passed by 58% of the vote. I think that the parties agree that the crux of the issue is that the question of how the measure operates, or basically plaintiffs are misreading the measure and how it operates. Now, the thread of our argument, I would say there's two threads. First, there's text, context, and legislative history. And that's from PGE and Boley, PGE v. Boley and State v. Gaines. And so we're going to talk a lot about text, context, and legislative history. And then the other thread is that many of plaintiffs' arguments, even if well taken, do not provide a basis to invalidate the measure. They are mechanisms to defend against enforcement. And so even if the court agrees with plaintiffs and disagrees with defendants, that still does not provide a basis to invalidate the measure. And those are sort of the two themes. So viewing the measure in light of the text, context, and legislative history, specifically the text of the actual measure itself in the context of the short-term rental section, and then pulling out a little further the business licensing chapter, and then zooming out a little further in the code, the whole Lincoln County code, and then the legal landscape, including the Oregon state law, Constitution. Only the county's interpretation is plausible here. And interpreting the measure as the county does, the measure was properly adopted, does not violate Oregon statutes, is not preempted, and is constitutional. Now, I'm going to try to sort of mimic the order that plaintiffs presented in, and I'll do my best to do that. So first, let's talk about ORS 203, and specifically the Ordaining Clause requirement. Now, ORS 203-045 sub 2 sub B says that the Ordaining Clause of an ordinance that's adopted by the electors shall read, the people of name of county, here, of course, Lincoln County, ordain as follows. And plaintiffs said that the parties agree that it doesn't contain an ordaining clause. And I just want to say that's not exactly right. I think the parties can agree that it does not contain that exact language, but the county's position is that there is text in the measure that satisfies that requirement. And that text is at the top of the measure itself, which, we submitted, plaintiffs submitted. It's an exhibit to my declaration. And at the top of the measure, it says sections 4.405 through 4.460 of Chapter 4 of the Lincoln County Code shall hereby be amended as follows. Now, I submit that that is an ordaining clause. And furthermore, combined with the marker in the voters pamphlet that the measure was proposed by initiative petition, it satisfies the requirement in ORS 203-045-2B. Now, I think I want to talk a little bit about the election cases, because we do rely on some elections law cases in our motion. And it's a little unclear to me whether whether this is an election issue or isn't an election issue. But I think that it actually helps to look at the ordinance that the plaintiff submitted with their reply, because that is the ordinance that initially created the short-term rental licensing scheme, and that document has the ordaining clause in it, right? The ordinance that passed the amendments to that licensing scheme in the measure, the document that did that was the initiative petition, and all of the documents that accompanied it, such as the ballot title, explanatory statement, all of those documents. I remember plaintiffs cited some cases that the documents that give vitality to the statute, they can't exist without, this language in these documents. The documents that do that with an initiative petition are the measure, the initiative petition itself, the voters pamphlet, and the ballot title, and the explanatory statement. So I think that the cases that we cite that support, examining the technical requirements to submit something for an initiative petition do apply here. When you review those cases, I think it makes clear that a court should be extremely cautious about overturning law because of a failure to comply with a technical requirement. And I think that is the case here, especially where that failure to comply with the technical requirement doesn't mislead the voters and doesn't affect the outcome of the election. And plaintiffs didn't argue, and I think it would be extremely difficult to argue that the text at the top of the measure itself somehow misled voters or affected the outcome of the election. So let's see. Lastly, I would say, even if the election cases don't apply, the case Beeman v. Kelsey that plaintiffs cited, where the city of Gold Hill enacted an ordinance and the language was not exactly as required in the statute. I think that stands for the premise that it is a matter of substance and not form. And here, the language in the measure, as well as in the ballot title and all the information in the voter's pamphlet, satisfies the substance, if not exactly in the same form. That we agree on. It does not contain the exact language in ORS 203-0452B, but it satisfies the substance of it. So therefore, that's not a basis to invalidate the measure. Now, next, let's talk about incorporated cities. So here, I'm going to talk a little bit about, the first thread I mentioned, the text, the context, and the legislative history. So the text of Lincoln County Code 4.425, the measure, says a person holding a short-term rental license or an interest in a property in R1A, R2, and R1A, R1, and R2 neighborhoods, and then shall not hold, and then back to the quoted text, a license for any other property within Lincoln County. Now, first looking at the text, R1A, R2, and R1A, R1, and R2 neighborhoods are county zoning designations. They do not exist in cities. So the text of the measure itself shows it does not apply in incorporated cities. Now, that reading is confirmed, I think dispositively, by the context. LCC 4.410 states that the entire licensing scheme, short-term rental licensing scheme, the entire section, LCC 4.405 through LCC 4.460, and this is a quote, shall apply to the unincorporated areas of Lincoln County. Now, plaintiffs say that we ignore plain text. I think that plain text is pretty clear. The entire licensing scheme shall apply to the unincorporated areas of Lincoln County. Now, I agree that if the text is clear, reference to the legislative history may not be necessary, so I won't talk about it here, but we briefed it. I think it confirms this understanding, confirms the text and context. And then I want to return to the second theme of our argument, which is even if even if the measure applied in incorporated cities in Lincoln County, that would not provide a basis to invalidate the measure. That would provide a defense against the enforcement of the measure, but it does not invalidate the measure. So let's say the county tried to enforce and, revoke a license or not provide a license in an incorporated city. It's hard to even imagine how that would operate because the county doesn't do that. But if they tried to, let's say they tried to in Newport, then the property owner would use 203-040 to defend against that enforcement. I think it's clear from the measure that it does not apply in incorporated cities, but even if it did, it would not provide a basis to invalidate the entire measure. So moving ever so slightly to the land use area, and I'm going to talk, again, I'll try to be brief, on the notice and hearing requirements in the land use law, and then I'm going to turn it over to Chris, who's going to talk about the sort of deeper land use questions. So the notice and hearing requirements in ORS 215, specifically 215503 and 215223. Again, plaintiffs say we ignore the plain text. I think the plain text of those statutes are pretty clear. The notice requirement in ORS 215503 applies to ordinances adopted by the governing body of a county. The measure was enacted by the voters through initiative petition. The notice and hearing requirement in ORS 215223 applies to zoning ordinances, again, enacted by the county governing body. Here, the measure was enacted by the voters through the initiative petition process. We cited the League of Women Voters case and also ORS 215110 to demonstrate that when the legislature wants a law to apply to the voters or the electors, it knows how to say that. ORS 215110, within the same chapter as these notice and hearing requirements, uses county governing body separate from electors. Now, I think perhaps county, if they just use the word county, that could apply to the electors. We know from the League of Women Voters case that local government does. But both statutes that plaintiffs refer to for notice and hearing requirements state the county governing body. And here, the measure was not passed by the county governing body. It was passed by the voters. Now, plaintiffs discussed the Riverbend case, which is a LUBA case. And I believe Ms. Anderson-Dana cited it already. And that states a final reviewable land use decision for purposes of LUBA review. And even more specifically, for purposes of timeliness, of review is not the same. Sorry, that's not what the case states. I'm, extrapolating from that. That is not the same as enacting a zoning ordinance for purposes of ORS 215-223, 215-503. So a zoning ordinance enacted by either the voters or the governing body, that is a final reviewable land use decision. But that's not what the plain text of the statutes apply to. They apply to ordinances adopted by the county governing body. And then just one last note. I believe Ms. Anderson-Dana said there's no dispute that individual notice was not provided. I think that there is a dispute because this measure was on the ballot. Every single voter in Lincoln County received notice of this measure through their ballot. So I just want to correct that. So to get more into the land use weeds, I'm going to turn it over to Mr. Crane to talk about non-conforming uses.
Thank you, Your Honor. Specifically, I want to address the question of whether or not the measure complies with ORS 215.130, this whole notion of non-conforming uses. As we said in our brief, the plaintiff's argument misconstrues or maybe just doesn't understand how 215.130 works. By its term, and as explained by the court in the Mosher v. River Sandy Gravel case, if a person has is using property lawfully, and then the law changes in a way that makes it unlawful, under 215.130 sub 5, you get to continue your use, notwithstanding the change in the law. But it doesn't invalidate the law that changes things. It says you get to continue doing it, notwithstanding the change in the law. The change in the law here is the initiative measure. Accepting plaintiff's factual allegations for purposes of this discussion, that they have a lawful short-term rental use, 215.130 sub 5 says they would get to continue doing that, notwithstanding the change in the law. It does not provide a basis to invalidate the law itself. 215.130 subsection 5 is a remedial measure. It does not provide a basis to invalidate an ordinance. What it does is say how that ordinance applies, and it would not apply to a person who has a lawfully established use prior to the enactment of the ordinance. Again, it does not provide a basis to invalidate the ordinance. And keep in mind that, again, just assuming the facts alleged by plaintiffs, that there are several hundred people in Lincoln County who have short-term rental licenses. There are thousands who do not. This ordinance applies to them on its face by its terms. There is no question that people who do not have an STR license do not have a lawfully established use. And so therefore they are not protected from enforcement of the ordinance. These plaintiffs might be under 215.130 subsection 5. Again, it's a remedial statute. It does not provide a basis to invalidate a measure. Which leads to my second point. If the use of a property for purposes of determining whether somebody has a non-conforming use is done by reference to the zoning code, as the court in Morgan said it must, the fact that Lincoln County's zoning ordinance still doesn't, frankly, address short-term vacation rentals at all means you couldn't have had a lawful use of the property under the city's zoning ordinance prior to the enactment of this measure. So these uses became non-conforming on the same date at the same time as voters approved the measure, which means it was subject to all of the limitations in the measure at the same time. In that regard, there's one restriction in the measure to which they object specifically, and that is the provision that says a short-term rental license or use is not transferable. And they say that violates 215.130 sub 5. Again, if that's true, then it can't be enforced against them, but does not provide a basis to invalidate the measure. But it's not true, because prior to the election, prior to the date the measure was enacted, the county code already said that these licenses could not be transferred. If the property was sold or the license did not transfer with the property. We cite to this language in our reply specifically, but you cannot, what they're arguing basically is that they want more rights than they had before the measure was enacted. Again, before the measure was enacted, under the express terms of the Lincoln County short-term vacation rentals, a short-term vacation rental license was not transferable. And now they're arguing that they should be allowed to transfer their licenses, in effect giving them more than they had even before the measure passed. The measure cannot deny somebody a right they didn't have in the first place. So the argument that 215, or that the measure somehow violates 215-130 sub 5 because they can't transfer their licenses is just contrary to the law. They never had that right in the first place, so the measure could not deny them that right. That's about all I have on the non-conforming uses, but I do want to pick up on this thread that the statute is a remedial statute. It provides a defense against enforcement of the measure if you had a lawfully established use prior to the enactment. You can point to 215-130 sub 5 and say that can't be enforced against me because I have a lawfully established non-conforming use. The same applies to their arguments under Measure 49, which I know Ms. Matazar is going to address, but that statute says if a measure restricts your residential use of the property in a way that diminishes the real market value, you get a remedy. Either you get compensated or the regulations don't apply to you. It does not provide a basis for invalidating the measure itself. Measure 49 is, again, a remedial statute. It does not provide a basis to invalidate the measure. And my final point on that thread is that the arguments under 203.040 that a county ordinance can't apply inside a city unless the city consents is exactly right. So Mr. Berman, in his arguments about how this applies inside cities, jumps immediately to canons of statutory construction to say, well, the courts have said when a term is used differently in different parts of an ordinance than different things were intended, as I'm sure the court is aware, you only get to canons of statutory construction if ambiguity exists after analyzing the text, context, and legislative history. Mr. Berman wants to ignore context and legislative history and jump immediately to canons of statutory construction. 203.040, as Ms. Matazar pointed out, is a remedial statute. If the county tried to impose this ordinance or enforce this ordinance inside the city of Newport, inside Lincoln City, on a short-term rental licensee, that licensee could point to this statute and say, your ordinance doesn't apply to the city, doesn't apply inside the city because the city did not consent. It is not a basis to invalidate the statute. So, and neither is 215.130 subsection 5. These plaintiffs may well have a non-conforming use. We're kind of getting out in front of the headlights on that. I don't know. But if they do, then 215.130 subsection 5 means that the county can't enforce the measure against them. It does not mean that the measure is invalid. Thank you, Your Honor.
So thank you, Mr. Crane. I'm going to pick up the thread, like Mr. Crane mentioned, and talk a little bit about Measure 49. And I think that Ms. Anderson-Dana laid out the questions exactly right. First, does it apply here? And second, does it preempt the measure? And I would argue the answer to both of those questions is no. So Measure 49, codified at ORS 195-300 et sec, applies when land use regulations restrict the residential use of property. And the measure does not restrict the residential use of property. Plaintiffs may continue all residential uses. I want to now just point to the plain text of the measure itself in the definition section, Exhibit 1 to my declaration in support of the motion for summary judgment, page 4, sub 15, says residential or residential use means the occupancy of a dwelling unit on a non-transient basis. Uses where tenancy is arranged on a transient rental basis are not considered residential. And then furthermore, sub 16 defines short-term rental. And the last sentence of that definition states that short-term rentals are deemed commercial lodging businesses equivalent to hotels and motels. They are not residential uses. The plain text of the measure itself states that the measure does not apply to restrict the residential use of property. And the cases that plaintiffs cite, including the Yogman v. Parrott case, is a contract case, a contract interpretation case. We're not talking about contracts here. We're talking about the measure and the Measure 49. And so I think that and furthermore, the Yogman case, plaintiffs don't even state that it conclusively defines residential use for all purposes. It says it stands for the proposition that that residential uses can include short-term rental. We're not saying it can't. We're saying that here it doesn't. So first of all, we disagree that Measure 49 applies at all here. But furthermore, we disagree that it preempts anything in the measure. So, of course, home rule has a strong presumption that a local law is valid. And to overcome that presumption, there must be either express preemption, which I don't think anybody's arguing exists here. That's, a local government may not create a law and violate, that disagrees with this law. That's what an express preemption is. Implied preemption is when the laws conflict. Now, that doesn't mean that the laws cannot be different, right? We have a lot of case law on what a conflict between a local law and a statute is. And it means both cannot operate concurrently. The Thunderbird case states that the operation of the local law makes it impossible to comply with the state statute. And that is just not true here. There is no implied preemption. The laws can operate concurrently. There is no conflict. So I'll talk a little bit about the particulars. So ORS 195.312 sub 2 states a person must file a claim, a Measure 49 claim under ORS 195.310 within 5 years. The Lincoln County Code 4.424 sub B describes the hardship relief and states that anyone seeking hardship relief shall file an application for such relief with the Board of Commissioners not later than 60 days. That is within 5 years, which is what's required under the state statute. They do not conflict. Both can operate concurrently. Under the preemption case law, it does not conflict. Likewise, ORS 195.310 sub 5 describes the relief for Measure 49 claims and states that a public entity, once someone states a valid Measure 49 claim under the statute, the public entity must, and this is a quote, must either A, compensate the claimant for the reduction in their value, or B, authorize the claimant to use the property without application of the land use regulation to the extent necessary to offset the reduction in fair market value. That is exactly what the measure does. The measure LCC 4.424 extends the amortization period beyond 5 years for people who are able to state that they invested in the property for this use, exactly the same as the Measure 49 requirements. It satisfies B. The statute is either or. Therefore, both can operate concurrently, and it's not impossible to comply with both. I want to talk just a tiny bit, because I think these two cases that we discussed are really instructive here. One is the Oregon Restaurant Association v. City of Corvallis, 166 OR App 606. It's a 2000 case on preemption. And in that case, the city of Corvallis passed an ordinance that prohibited smoking in enclosed public spaces. The state law at the time, the State Clean Air Act, prohibited smoking in enclosed public spaces except in designated smoking areas. And The plaintiffs, I believe they were restaurant and bar owners, challenged the provision as preempted. They said, this is too strict. In closed public spaces, we get to have a designated smoking section. And the court said, no, there's no conflict, there's no preemption. Nothing in the act, and this is a quote, nothing in the act, the Clean Air Act, is inconsistent with a local jurisdiction's decision to impose greater limits on public smoking. If you imagine that case applying here, nothing in the Measure 49 is inconsistent with a local jurisdiction's decision to impose faster deadlines, like they do here. That case, Oregon, I want to give just one more brief example. The Oregon Restaurant Association case relied heavily on state ex rel Haley v. City of Troutdale, 281 OR 203. That case was decided on the same day as the LeGrand Astoria versus Perb case, the preeminent preemption case in Oregon. And in the Haley v. Troutdale case, the state building code required single wall construction in their building code. And the city passed an ordinance that required double wall construction. And I believe it was a group of developers challenged the case, or the city law, saying it was preempted by the state law. The state says that it should be single wall construction, and the city is preempted from passing double wall. And the court disagreed and said there is no conflict, there is no preemption. And here's a quote. The claim is not that the buildings complying with the ordinance would violate the state's regulations, but that the state legislature has excluded regulations other than the state's. And that is not what preemption is. That is not what a conflict implied preemption is. And I think that is very analogous to the case here. The statute states that a person must file a claim within 5 years. The Lincoln County Code provision passed by the measure states the same. Person must file a claim within 5 years, not later than 60 days after the regulation is passed. And the same is true of the relief. So there is no preemption. We argue that Measure 49 does not apply because it's not a residential use, but also it's not preempted, even if it did. I think, so the last subjects are the constitutional questions, and I think I will try to be especially brief on these. So I think the contract clause, Mr. Berman introduced his speech by saying they're bringing a facial claim of that the measure is facially invalid. And I just think that the case law shows that contract clause, Article 1, Section 21, facial claim, the standards are extremely high to bring that. It cannot apply in any circumstances. Oh, I'm sorry, that's the vagueness claim. Nevertheless, the Article 1, Section 21 claim is still very high, the standard. The elements of it are, is there a contract? If so, what are its terms? What obligations do those terms require? And has the state impaired an obligation of that contract? And plaintiffs don't even argue that it has or that it does. They argue that to the extent the measure might affect the plaintiff's use, then it would violate the contract clause. And the case law just shows that that's not enough. As for the vagueness, I think I'll just, stand on our pleadings on that, unless the court has any questions. And then for severability, I'll talk a little bit about severability. So, of course, the county's position is that all of the measure is valid. None should be, no part should be severed. No part is unconstitutional. And a severability analysis is not required here. But if the court disagrees and any portion of the measure is unconstitutional, then we argue that that portion should be severed. And there's a few reasons why. First, in the plain text of the code, there is a severability clause in LCC 4.460. And I think plaintiffs argued that severability clause didn't appear in the measure. But I disagree. It appeared in the petition that was submitted as the measure. The entire short-term rental licensing scheme, as we've discussed, was submitted as the initiative petition with the changes in bold and italics. And in the initiative petition, this severability clause appeared. And that severability clause states, each section, sentence, clause, and phrase hereto is declared severable. If any section, sentence, clause, or phrase of this chapter is adjudged by a court of competent jurisdiction to be invalid, the decision shall not affect the validity of the remaining portions of this chapter. So we argue that that severability clause controls, the portions are severable, and that ends the conversation. But even if that is not true, even if that severability clause was not there or does not somehow apply, there's still a strong presumption of severability, as Mr. Berman said, codified at ORS 174040. And plaintiffs just simply do not rebut that strong presumption. The statute there's 3 ways listed in the statute to rebut the presumption. And the first is essentially an inseverability clause, a clause that says, this shall not apply if any part. Secondly, the remaining parts are so dependent that it would not have been enacted, but for the unconstitutional portion. And third, the remaining parts standing alone are incomplete and incapable of being executed in accordance with the legislative intent. And the question is not whether the legislative intent was to pass the unconstitutional portion. Because if that were true, then the court could never sever, right? The question is whether the remaining parts are capable of being executed in accordance with the legislative intent without the severed parts. And we argue that it may, that if the court finds any portion of the measure unconstitutional, then that portion may be carved out. I think that is where I will conclude. I'll throw it over to Mr. Crane to see if he has anything he wants to add.
Thank you, Emily. Mr. Madisar, Your Honor, just one thing briefly on the attorney fees. Whether plaintiffs' claims are objectively reasonable under 20.105 is a question for the court. Obviously, they think they are. We obviously think they aren't, ORS 203.040, ORS 215.130, Measure 49 are all remedial statutes or provide a defense. There's no basis in those ordinances or no statutes to invalidate, no objectively reasonable basis in those statutes to invalidate a local ordinance. But in any event, we simply disagree on that question, and that's why the court is here to make a decision. In any event, it's clearly properly pled, and in the event one side prevails in this court rather than, say, at LUBA, we will have a discussion under ORCP 68 whether or not there was any objectively reasonable basis for their claims or whether they're entitled to fees under the Terrace line of cases. But there's no question that the county's request or demand for attorney fees is properly pled. Thank you, Your Honor. I think that's all we have on their motion.
Thank you. Okay, intervener, Mr. Cairns.
Thank you, Your Honor. For the record, Daniel Cairns on behalf of the interveners. I don't want to plow a lot of this ground that's been handled in an abundant pile of pleadings and in our almost 2 hours of arguments so far today. I'd like to hit kind of a few high points, respond to things that you've heard today in this argument. and otherwise rest on the pleadings that we've filed in this case. We didn't file a reply, by the way, kind of in that theme that I think you've seen enough of this already, and you have enough before you to decide this case. A starting point is I think that this case is subject and eligible for summary judgment. As you can see, no one's really arguing a whole lot of facts here. It's all what does the law provide and how should the case be resolved. Let me begin, I guess, with some of the things I heard from the plaintiffs. They begin their motion, they begin their case, and they end it by citing the authority of the county's former attorney. And a lot of people expressed a lot of opinions about this ballot measure. It was hugely politically controversial. And I think that's why you get a lot of opinions from political figures in the county about whether it should or shouldn't pass or what should happen. There's no doubt about that. That doesn't go to its legal soundness or not. You know, would you have drafted it differently? Would Mr. Crane drafted it differently? Would I have drafted this measure differently if that had been our charge? I think we would have. But at some point, someone's got to write this thing down and send it up the flagpole with the voters, and that's what happened here. And so I don't think that the former county council has any authority in deciding whether this measure is legal or not. Also, the Oregon appellate courts have said repeatedly, because of Oregon's unique land use system, that they don't really care what other jurisdictions say about land use law or what Black's Law Dictionary says about land use law. So I don't think I've ever cited Black's Law Dictionary for what zoning ordinance means when statute defines what a land use regulation means. And that's the operative term that you need to decide. In this case, is the measure a land use regulation or not under state law, Oregon state law? As I'm sure you know, as we all know, that local voters can adopt land use decisions by initiative and by referendum, but they can't do so with quasi-judicial land use decisions. You know, there are two kinds, legislative land use and quasi-judicial land use decisions. So a lot of the cases, I'd say all the cases that the plaintiffs are citing, have to do with the validity of initiative measures and referendums adopting quasi-judicial decisions, and those just aren't eligible for adoption by the voters. Legislative, for sure, is. One of my clients, the city of Tangent, has a charter provision that requires all amendments of the local zoning ordinance and comp plan to go to the voters. That's how it works in Oregon under our constitutionally guaranteed right of initiative and referendum. In Article 4, Section 1, that's critical power reserved to the people of Oregon. And so a lot of the statutory references that plaintiffs use to invalidate this, I don't think the legislature has the authority to do that, especially when the remedy these people are seeking is invalidation. If you look at the ordinance they're citing, 203 sub 040 about the ordaining clause, what's conspicuously absent there is any kind of remedy. And I'd suggest to the court, as I have in my pleadings, that invalidation is not one of the remedies available when there's a missing ordaining clause. And plaintiffs haven't cited a single case that says that the absence of an ordaining clause in an initiative measure, which is critical, invalidates the measure. The Supreme Court's been pretty clear that you don't do that lightly. Lindstrom v. Myers, the invalidation of an election is a severe sanction and should not be lightly undertaken. And remember, it is a constitutionally guaranteed right that's reserved to the voters. And they go on to say that it is a matter of balancing the seriousness of the defect against the consequences of invalidation. Before the electorate will be disenfranchised by anyone's failure to comply with the statute, the failure must be one of considerable magnitude which threatens the purity of the ballot. And in this case, I think the purity of the ballot is decided by, did the voters know what the heck they were doing? And so you look at the title of this measure, amendment of Lincoln County sections 4.405 through 4.460, short-term rental regulation of dwelling units. The county's also has already pointed out how this particular section is captioned. Lincoln County Code shall hereby be amended as follows, and it explains that new text is in boldface, things that are crossed out or bracketed that will be deleted. There's no question as to what was happening here, and so I think you need to decide all these issues that have come before you. I think the place you need to start is by reading this measure. And most of what's in the measure is the existing code chapter. That's going to remain. It's going to stay the same, including the severability clause, which is 4.460. And what this measure does, what the entire short-term rental regulation chapter does, if you listen to plaintiff's case, it sounds like a zoning ordinance that it dictates what property owners can do or can't do. That's not how this works. That's not how the licensing regulations work here. It limits the county's authority to issue and renew licenses. So when I say look at what's already in the code, section 4.430 says these licenses are good for a year, and you have to renew them every year. And how is it implemented? Well, it's implemented 30 days after a determination is made, which is in section 4. Let's see, I'll get the section number to you in a second as to how it's implemented, but it's implemented on the annual review date. This doesn't apply directly to the operators. It applies to the county when it renews these licenses as they come before the county for renewal every year. And so to say that these operators have a right to continue to persist definitely that is like a zoning ordinance is sort of crazy in the sense that you don't apply for a license every year to operate a use that's allowed outright. So it's section 4.440, subsection 7, which is new here, says reductions in occupancy shall become effective within 30 days of determination. So that's not a defined term, but determination, I think, in the context of that section means your license renewal or your license application. There has to be an inspection. Do you meet all the requirements to operate a short-term rental in Lincoln County? That's made. And so it's sort of crazy to say that you get a non-conforming use right for a license. I mean, we don't claim that with our driver's license. We don't claim that with, grazing rights. We don't claim that with licenses to log in this state. So it seems sort of not consistent with this code chapter to say that there's some sort of uber right that exists and the county lacks the authority to review license applications or renewals. It's also important to see that this, as a legislative amendment adopted by the voters, that it doesn't affect any particular permits. It's not quasi-judicial. It applies generally throughout. And so licenses generally are transferable or not transferable depending on what the license regulations provide. I think it's incorrect to look at these licenses as the same way that non-conforming uses are regulated under the zoning ordinance. In this case, they're transferable according to the regulations adopted by the county, and this particular set of regulations said they're not transferable. You can't transfer your driver's license. There's no reason to expect that these should be transferable unless the regulations say they can be transferred. The references to non-conforming uses and it seems like Morgan v. Jackson County. I think you see everybody citing that case in support of their positions here. As a practitioner in the field, Morgan v. Jackson County was sort of a big change because the statute itself, 215-130, simply says you have to be lawfully and in existence at the time restrictive zoning is applied. And so it was assumed by city attorneys and practitioners that lawfully in existence meant lawful, all the various laws and regulations that apply, not just land use regulations. And this case changed that. It said that business regulations, non-land use regulations, do not enter into the consideration of whether something is non-conforming or not. And the plaintiffs in this case cite Jackson County only for its dicta as to how the court characterizes what a business regulation is or isn't. The fundamental holding of the case distinguishes between land use regulations and non-land use regulations, like business regulations. And it says, kind of as by way of dicta, that a business regulation is something that doesn't dictate where something can exist, where a use can exist. It wasn't the focus of the case at all. That was just dicta. But it's pretty clear that this case draws that big distinction under the statute that is before you between regulations that are land use and those that are non-land use. This is non-land use. And you can see why that's the fundamental question in this case. Is it a land use regulation or not? Because the vast majority of the objections that plaintiffs have to this case, they're totally invalid if it's not a land use regulation. Completely. I mean, some of them these land use regulations only apply to the governing body, for example, by their terms, and I think it's quite a stretch to extend that to the voters of the county. So the case law certainly doesn't support that extension. And I go back to the most analogous case that's been cited to you is Oregonians in Action versus City of Lincoln City. And as I mentioned before, it challenges 3 different ordinances that Lincoln City adopted. One of those was a revision of its zoning ordinance, its land use regulations. Another ordinance that issued there amended its short-term rental chapter, very similar to what's happening here. And in their reply, plaintiffs cited for the wrong ordinance that was being challenged in that case. The zoning ordinance in Lincoln City for sure is a land use regulation. There's no surprise there. But what LUBA did was dismiss the challenge to the short-term regulation amendment because it wasn't a land use regulation itself. So I would refer you to Lincoln City's short-term rental regulations, and the plaintiffs in this case, in their efforts to drag this set of business regulations, business license regulations into the land use regulation statutory category, they say, well, it refers to zones. Well, if you look at Lincoln City's, it refers to residential zoning 9 times. They say, well, it refers to use, therefore it regulates uses. Well, Lincoln City's short-term rental regulations refer to the term use 43 times. There's no way you can separate how businesses operate, because it's a use, from zoning. There are 2 sets of regulations that would apply to a particular business. That's true in Lincoln County. That's true in Lincoln City. It's true in every jurisdiction that I practice in. But that doesn't mean that the business licensing regulations on one hand are the same as or can be conflated with land use regulations on the other. I think that the county, when it adopted its ordinance that LUBA has now dismissed and transferred, it's Ordinance 532, I think, there aren't, I'm not aware really of any cross-references to the county zoning ordinance. This measure has a few, just like Lincoln City's did. This is no more a land use regulation, though, than was Lincoln City's ordinance. And those cross-references are very common. And as someone who drafts a lot of these ordinances, if we did not have available the term non-conforming use, I'm not really sure what we'd use. The old vernacular was grandfather rights. It's a little imprecise when drafting code language. non-conforming use is a little more precise, but I would suggest that doesn't mean you rope in the entire body of ORS 215-130 and all the case law from LUBA and the appellate courts that relate to it. There's no basis for that. It definitely captures a good understanding of what the situation was. In this case, if you are a short-term rental operator, you had a license, you come in for your annual renewal, you're subject to these new regulations. If you don't meet these requirements, you don't get your license. It's not like you have an ongoing use forever. In this case, though, the provision, the new requirements here, the new regulations, they would allow you to continue to operate in that non-conforming status for 5 years as a way to recapture any investment, any expectation-backed investments you had made in your short-term rental for its use as a short-term rental. Understanding here that these are not, for example, billboards that can't be repurposed for anything. I would say, and what I've said to all my clients, the best repurpose of a short-term rental is a long-term rental. They can all be used, in fact, quite profitably as a long-term rental. So that was the reason for this 5-year amortization provision that was put into these regulations to allow people who already have a license, that are already operating a short-term rental, their license is not renewed because it doesn't comply with the new regulations. 30 days after the determination is made, they can continue to operate for 5 years. So that, again, does not convert in this set of regulations into land use regulations. The severability question was sort of a head scratcher for me. If you look at what was adopted, and again, I recommend you begin with reviewing the code chapter. It contains a severability clause. It just doesn't make sense to me to put a second severability clause into a measure that amends, that revises a chapter when it already has one. In case the voters didn't know what they were doing, as the county pointed out, the entire chapter showing what's new and what's old was attached to the measure. It is the measure. And so there's no doubt that it has a severability clause to it. And if that weren't enough, the statute raises a presumption of severability in this case. Throwing the baby out with the bathwater arguments on vagueness. I've drafted code language for many, many years. We always try to make it as clear and precise and unambiguous as possible. But guess what? We don't always make it. And, I know I have a good idea how this will be implemented by the county going forward. There's some provisions that might be a little ambiguous as to how it would work. And I think Mr. Berman pointed one out where if a short-term rental operator had some licenses within some of the cities in the county and came in for a new license or a renewal in the county, which licenses would be tossed out and which wouldn't. I'm not really sure how that call would be made by the county administrator that's administering this set of regulations, but that doesn't mean the whole thing is invalid. Every set of regulations has a few ambiguities, especially when you get 3 or 4 lawyers involved to point them out to you. So I would say those are not fatal defects to this. They would certainly not invalidate it. You need to go to back to the balancing test of whether did the voters know what they were doing? Was this anything confusing about this? For example, if it lacks an ordaining clause. Just one final note on the ordaining clause. I think what the remedy they're looking for, plaintiffs are, is that this would be invalidated, and then that my clients would run this back up the flagpole with the voters with an ordaining clause, as though that solves anything, as though that makes it more clear what's going on here. That seems nonsensical to me. by way of a remedy. I suggest that the Supreme Court has already given pretty clear direction as to whether that would serve as a fatal flaw, a jurisdictional defect in the world of court, or not. I'd suggest it's not. A lot of the procedural measures kind of fall into the same category that the plaintiffs have raised. Measure 49, for example, if anyone among the plaintiffs has a Measure 49 claim, I suggest they file it. I suggest they not ignore what Measure 49 provides, and the county will be obligated by state law to process those. It's totally irrespective of this measure and whatever additional or different remedies it provides. I don't really see any conflict there at all. The county was correct in what Yachats v. Parrott means. It does not stand for the universal proposition that STRs are residential in nature. That was a case that interpreted CC&Rs applicable. So reading the CC&Rs, what do they provide? Is it residential? Is it commercial? It didn't resolve the question, so the court tried to figure it out and concluded it was more akin to residential than commercial. But there weren't any county regulations in that case. There weren't any, it wasn't a defined term in that set of CC&Rs. In this case, it is a defined term. In this set of regulations, it says that short-term rentals are commercial use. So I really don't see that Yachats versus Parrott has any applicability. Measure 49, again, kind of deals with, is it residential, is it commercial? It only addresses land use regulations that limit the use of residential properties or residential use of properties. Again, I'd recommend Oregonians in Action versus City of Lincoln City. Only a few pages, 2 pages of it, in fact, is relevant here because of the 3 ordinances that were challenged. Only one of those ordinances has any relevance here. It was Lincoln City Ordinance number 2014-23, not as a plaintiff's cite, Ordinance 2014-21. That was the ordinance ending the zoning regulations for the county or for the city. That, and I would echo everything the county said in this case, are the comments that I have for you, Your Honor, and I stand by if you have any questions for me about our arguments. Thank you.
Thank you. Does anyone have any responses that they would like to give the court?
Your Honor, on behalf of plaintiffs, unless the court has any questions, I would ask the lawyers on the call. I think we've gone back and forth. I'm trying not to be argumentative in this moment. We've briefed this extensively. We've argued this extensively. I think we could each get caught up in pointing to things that our opposing counsel has said. I'm not sure that would benefit the court. If the other lawyers on the call are willing to kind of stop arguing and let the court take it under advisement, I would be happy to do that. If not, I can talk for as long as the court will let me. But I think that the former might be preferable to everybody involved here.
This is Emily Madisar. Oh, sorry, Your Honor, go ahead.
I was just going to say,
Your Honor, I was just going to say that's fine with me, and I see Mr. Crane nodding as well. So I think that
Your Honor, there is one thing I would like to address very briefly. In the plaintiff's reply in support of their motion for summary judgment, in footnote 1, they suggest that the county is changing its position on jurisdiction, whether or not this is a land use issue. And I just want to underscore again, that is not the case. We have been clear since the very beginning, since the plaintiff sought adjunctive relief. We believe this is a land use measure. I respect Mr. Kern's interpretation on that issue or his analysis of that issue, but we remain consistent and have been throughout. whether or not we opposed or supported a stay at LUBA has no bearing on this court's jurisdiction, and conflating those issues and suggesting the county has changed its position. I just wanted to clarify that is not the case.